I'd like to welcome you all this afternoon to our program, The Filibuster and the Pace of Judicial Confirmations. This is the second in an ACS series entitled The Future of the Courts, Nominations, Confirmations, and the Pursuit of Justice. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy, otherwise known as ACS. We are a national network of lawyers, law students, policymakers, and judges dedicated to promoting the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. Many commentators have noted the increasingly frequent use of the filibuster, or the threat of filibuster, in recent years. Concerned court watchers have examined the pace of judicial confirmations in the first year of the Obama presidency and compared it unfavorably to President George W. Bush's first year. Many suggest that the filibuster threat is to blame for the slow pace of nominations and confirmations and has increased the scrutiny on this Senate rule. Today's panel brings together experts to examine some serious questions, such as, what are the filibuster's historical origins? And what is the current status of the filibuster? Does it actually exist? What are the prospects for change, given efforts like Senator Tom Harkin's recently introduced legislation to reform the cloture procedure? How does the filibuster's use in judicial nominations compare with its use in other contexts? And what other Senate rules are there that might contribute to the slow pace of the confirmation process? And some of these questions deal with history and theory, but we should also remember that there are very important ramifications, which are neither historical nor theoretical. A judiciary with many vacancies puts a strain on existing judges and their staff and slows the speed with which cases are heard and adjudicated. That gives us the prospect of the delayed carriage of justice. I hope that these very real stakes will function as a backdrop for today's discussion. Now, our moderator is going to introduce our very distinguished panelists, but I have the pleasure of introducing our moderator, Professor Sarah Binder. Sarah's impressive biography is in your handout, so I'm just going to give you a very few of the many highlights. Sarah is a senior fellow at the Brookings Institute and a professor of political science at George Washington University, where she specializes in Congress and legislative politics. She is widely published. Among her works are Stalemate, Causes and Consequences of Legislative Gridlock, which is pretty relevant to today's discussion, and Politics or Principle, Filibustering in the United States Senate. We could not have somebody more knowledgeable about the issue we're going to discuss today. And most recently, Sarah co-authored with Forrest Maltzman, published last year, Advice and Dissent, The Struggle to Shape the Federal Judiciary. We are so fortunate to have Sarah to lead this discussion. Sarah?
Thank you, Caroline, for the very nice introduction. Because this is a panel about the Senate, I have negotiated a very complex unanimous consent agreement on how we are going to proceed. So I asked unanimous consent, and barring no objections, we'll do it this way. I'm going to introduce our speakers as we go down the table here, say a little bit about Marty. Each panelist will speak for about 5-10 minutes, however they would like. I'll pose a few questions to the panel, and then we can open it up for your questions. So first, Marty Paone, and the detailed biographies are here, so I'll just give you the highlight of why we have come to the panel together. Executive Vice President of the Prime Policy Group in Washington, most remarkably served on Capitol Hill for 32 years, and particularly for purposes of this panel, from 1995 to 2008, was the elected Democratic senator for the Democratic caucus in the Senate, which puts him essentially as the right or left-hand man for the majority leader. And I'm going to, since the details are there, I'm going to open it up to Marty, and then we'll move on down the line.
Yeah, as secretary for the Democrats, it was dependent on the year, secretary for the majority, secretary for the minority, depending on the election. You know, I had two sets of boxes, boxes of cards, and you just never knew, you know, after which election, which set of cards you were going to use. And also that colored your opinion as to whether the filibuster was something good or not, and also who was in the White House. I don't know how much into the weeds you want to get into this as far as process. My daughter Warren tells me that I should bring a supply of 5-hour energy drink for everybody in the audience when I talk about things like this. But the Senate, like our democracy, is an evolving place. I mean, the senators used to be elected not by the people, but by the legislators. You know, women didn't have the vote, and so on. You know, everything's, you know, over the years have changed. The Senate's no different. The rules have changed. Up until 1917, there was no such thing as the ability to cut off debate. That's where Rule 22 was first brought in. That allowed 2/3 of those present and voting to shut off debate. It was following an outcry of a minority that held up a bill that would have armed merchant vessels. And they were brought in after the Congress ended and other bills ended. It failed at the end of that Congress. They came right back like 5 days later. In March of 1917, started the next Congress, and the majority leader at the time had to threaten to use what is called a constitutional option, which I'm sure we'll get into at some point here. And in order to, with the argument that at the beginning of each Congress, the majority should be able to set its own rules. He didn't have to go to that extreme. They were able to pass the rules change, and then thereafter, you had the ability to cut off debate. It was rarely used until you got up into the 50s and 60s. And then it was used in the civil rights era a great deal. For instance, you know, in 1937-38 Congress, it was used twice. Two cloture motions were filed, no cloture votes occurred. You know, you didn't have a cloture vote from 37 onward until 61 was your next cloture vote. You didn't have any prior to that. And so now, it's a far different situation. I mean, and it's changed over the years. It was as I said, it was 2/3 those present in 1917. And the way they worded it was only on a pending measure. Well, in the Senate, you have motions to proceed to the items in order to call them up. And so in order to call up legislation, a lot of it, some of it was civil rights, but I mean, this was in the 40s. The opponents would fight the motion to proceed, and they said, well, since the rule says it's only on a pending measure, the measure's not pending yet, so you can't file cloture. And the vice president, at one point agreed with them. Another vice president disagreed with them. Finally, in 49, they corrected that, and they had it apply to any measure, motion, or other matter. And as a result, nominations got pulled into the mix. Up until then, they weren't even included in the mix. 1959, but they changed it. They went from 2/3 present to 2/3 sworn. Well, you can see that's a higher, tougher number to make. 2/3 present just depends on who shows up that day. 2/3 sworn, you're going to have a harder number to hit. 1959, LBJ's in, majority leader. And again, you had members of his party wanting to use what is called the constitutional option, beginning of a Congress, setting new rules by majority vote. He headed that off and came up with an alternative of his own. And he was able to succeed after a number of days of debate. But he put it back down to 2/3 present as opposed to sworn. But he had to put in the rules. It's one of the rules that says that the Senate is a continuing body, because this was the argument that the constitutional argument the folks at the beginning of each Congress would make. Yes, it's a continuing body, but that we should have the right, the majority should have the right to change the rules at the beginning of each Congress. The folks that agreed to this 2/3 present, insisted that this be put into the rules, and that any further rules change had to be in accordance with the existing rules. Well, and so that meant, and a motion to proceed to the rules change was included. Up until that time, you couldn't even file cloture on a motion to proceed to a rules change. They hadn't fixed that yet. And so that's how it was until 1975. In the 60s, there was a lot of frustration of people filibustering civil rights legislation. And again, you had, in the 60s, at the beginning of a number of Congresses, you had rulings by Humphrey, Vice President, and Rockefeller once, regarding the fact that at the beginning of this Congress, we should be able to change the rules by majority vote. They didn't avail themselves of that time, but there was a threat of it, and there were some rulings that were troubling. So, but they did agree in 1975 to change it from 2/3 to 3/5, which is where you are now. 3/5 of those sworn. So it's a hard 60 if 100 senators are serving. But they left a motion to proceed to a rules change or anything relating to rules changes at the 2/3 present. So it's still a higher threshold. So you can see where it's still very difficult. If you're going to change the rules, you're going to need pretty much consensus to change the rules. But having gone into all that background, I'm a Democrat that I must say, and despite the fact that, you know, my president may be hitting some rough patches here with his nominations, that still supports the filibuster. I may want to see how it's employed, how it, you know, you flip different ways of requiring filibusters, i.e., you could put in as something that would change the rule as opposed to 16, right now 16 senators sign a cloture motion. You file the cloture motion on a Monday, 1 day plus 1 hour after you convene. So this would be Wednesday morning after you convene. 1 hour later, you would have your cloture vote. If it's a piece of legislation that is amendable, the day, interim day, people have until 1 p.m. to file amendments, germane amendments. Well, they can file non-germane amendments, but if they call them up after cloture is invoked, then a point of order will lie against them and their amendment will fall. And 1 hour prior to the cloture vote on that Wednesday morning, people can file second-degree amendments. Obviously, none of this comes into play if it's a nomination. But I could envision changing a rule to put more of the onus on the minority, because now you're seeing filibusters just to delay. And then you're seeing 99-0 votes once the vote actually occurs on the nomination. So I could see something where you could change the rule that says, all right, with a certain amount of notification, if the minority doesn't produce something signed by, say, 25 members, that they intend to vote against this nomination, then, you know, at the end of a certain, you know, at the end of the next day by, say, 5 o'clock or 6 o'clock, they have to produce such a petition, such a motion signed. Then if that doesn't surface, then there'd be a vote on the nomination. So rather than having the onus on the majority getting 60 and then having everybody just waste the 30 hours and vote for the nomination, it's require the people who are opposing it to show that, yes, there is real opposition to this nomination. That's just one thing I throw out there for food of thought. And I think I've probably gone too long, and I apologize.
Next is Macon. Thank you, Marty. Macon Del Rahim comes to us from L.A., law firm Brownstein, Hyatt, Farber, and Schreck. But specifically for his expertise, we brought him because he was the former staff director and chief counsel when Senator Orrin Hatch had chaired the Senate Judiciary Committee. After service on the Hill, he then was Deputy Assistant Attorney General in the Bush Justice Department starting in 2003. So we turned to Macon for a little bit about his experiences with Hatch and his perspective since.
Thanks so much. Thanks for having me, and good to see some old friends from the Senate here. There's a lot that Marty and I probably agree with, and he went through and did a nice analysis of the history of the cloture rules and filibusters. And I think probably the most important thing we need to define and agree on is what is a filibuster. In a filibuster, it is when you are preventing action by the debate and you're blocking a motion for cloture. I think the ability to debate is the fundamental right of every senator and their constitutional right, and they should be able to. The Senate, when it became unruly, the Senate did put in place certain rules And I think there's probably a lot of room for reform, but through the history, and in fact, when the Senate first met in 1786, there actually was an immediate cloture rule. There was a call for the previous question, which when the Senate in 1806, the rules of the Senate were ratified, was done away with. And then for about 111 years after that, you had no way of ending debate. And then, as Marty said, it became because of a major national issue dealing with World War I and a communication between the Germans and the Mexicans about how they're going to provoke the United States into World War I, and some master plan between the Germans and some folks who were some isolationists in the Senate who were trying to filibuster debate on the issue, and folks got together and said, okay, we need to change this. The important thing, though, was when the cloture rule, the original one, the 2/3 of those sworn and voting was put in place, and it's gradually changed, as Marty just explained, from 2/3 of voting to now it's 3/5 of the whole Senate. There was strong agreement. It preceded by lots of debate of whether or not the general rules, because every time you have a cloture petition, you're infringing on, rightly or wrongly, a senator's right to debate a particular issue. But when it becomes dilatory, I think it is problematic for the Congress and for the government. But they, in the very first rule, when they put in the original cloture rule, that passed 76-3. Broad agreement amongst the senators to limit debate amongst themselves. And then later in the 50s, you had the Douglas-Russell debate about civil rights, and yet again, when dilatory tactics were put in place for nefarious reasons, rules were changed again, masterfully by former Majority Leader Senator Byrd in a number of ways, and again, done in a bipartisan way. But I think we got to define what is a filibuster. It's when a cloture petition fails. It is, because it's not when you refuse to grant unanimous consent, because when you're asking unanimous consent of senators, you're saying, do you agree to this next action? Nomination, move into, proceed, or whatever it is. If they say, no, I don't, you can't force them to do so. But if within the rules, a cloture petition is filed, it only takes 16 senators. If 16 people in the Senate can't agree on a matter, then it probably doesn't deserve to move forward. But assuming you have the 16, then you go to a vote. And if you could get to 60, and if cloture is invoked within the rules of the Senate, then there is no filibuster. I think, with respect to judicial nominees, we can get into all sorts of statistics. I wasn't the chief counsel at the time, but I worked from '98. That's when President Clinton was in power and Republicans controlled the Senate. There was a lot of debate, going back. If you really, you can get back to probably the '80s when the judicial confirmation process started hitting lower and lower and lower and lower ground on both sides of the aisle. It was not, I don't think, either side, but one side felt aggrieved by their party in power at the White House, and the other side felt the same. We can get into various numbers and how long it took President Obama's nominees to get confirmed, and how long it took President Bush's nominees to get confirmed. I don't know if that really helps solve the issue. But the one thing that does concern me, and it was something that even when President Bush was in the White House and Republicans controlled the Senate, and I was fortunate enough to serve there, I thought it was a concern. And that is, and I think we need to make a distinction, and I don't know if Marty would agree with me, but I think with respect to the Senate's rules and whether you agree with a particular policy, when it comes to legislation, you can have whatever rules they set for themselves, 50 votes, 60 votes, 100 votes, whatever it is, and as long as they debate amongst themselves and set their own rules. When it comes to judicial confirmations, I have a real problem with the filibuster. Now, I say that not because I particularly want to see President Obama's nominees to get through or former President Bush's nominees to get through. I think there's a real problem is that it eats away to the core of the Senate and the decorum that the Senate is and should be known for, because it poisons the well. What I mean by that is that, this aggrievement back and forth. But there's some practical reasons that will prevent a real solution unless the solution is effective sometime with the next president. I had recommended a particular rule change with the next president when President Bush was in power. I said, whoever is the 44th, we don't know who that's going to be. And I recommend us to think about, actually probably not us, but those folks who matter, who hold certificates of election, to really debate and think about the effect on what's supposed to be a nonpartisan, equal branch of government in the judiciary. And when you impose a 60-vote requirement on judges, a particular former Senate Majority Leader or Senate Minority Leader at that time said there cannot be amount of time in the universe imaginable for me to debate this particular nominee. Well, that's not a real interest in debating the qualifications of a particular nominee. That's a filibuster. And, that's when a nominee has more than a majority and bipartisan support. I think, the framers of the Constitution, there's 5 areas in the Constitution: impeachment, expulsion of a member, ratification of a treaty, overriding a veto, and amending the Constitution that required supermajority votes. They debated the confirmation of judges quite a bit. They went with a simple majority. And I think there was a reason for that. And for the Senate, by its own rules, to do otherwise for judicial and executive branch nominees, I think raises issues about the imbalance in the branches. And that's where there's a real constitutional issue. But I think the practical solution is to come up with a lower threshold for confirmations, starting with a future president, regardless of what the party is.
Thank you, Macon. And I'm sure we'll come back to some of these reforms that you've been talking about. Finally, turn to Matthew Iglesias, fellow and senior editor of the Center for American Progress Action Fund. He has a long career at other publications, The Atlantic, American Prospect, and also Talking Points Memo. I think most of us know him from his daily, if not more than, can you be more than daily?
I don't know.
Daily blogging for Think Progress in the Cap.
Sure. Well, I guess, just a few sort of additional points of emphasis. One thing I would say is that although the filibuster and the cloture issue is technically about, debate, and defenders of it talk about debate, I think it's worth being clear that actual debating of issues is almost invariably a red herring in these kind of contexts, that when you have a minority of senators saying they won't grant cloture on Craig Becker's nomination to the NLRB, that's not actually because they have more things they want to say about it. It's, a tactic that you see has dual uses. One is to impose a supermajority requirement to say that you can't pass a bill or confirm a nominee unless you have 60 senators rather than 50. And the other, which in some ways I think has become more important and underrated, is to purely delay action. That the process of filing a cloture petition and letting it ripen takes quite a bit of time, particularly because you can sort of dual track your refusal to grant unanimous consent and force multiple filings of petition to ever get to a final vote on an issue. When it comes to a really big bill that's a huge priority for the congressional leadership or for the White House, that kind of delay is not a big deal. Maybe something passes a few days later than it otherwise would have, but at the end of the day, if you have the votes to pass it, you have the votes to pass it. When it comes to nominations, though, that's quite a bit different. There are thousands of positions that the president is supposed to fill by nomination, both in the executive branch and in the judicial branch. And it's often simply not worth the time of a congressional majority to spend several days letting cloture petitions ripen when you're talking about an assistant secretary of something, when you're talking about a district court judge. And so it's become possible for very, very small minorities of senators, as few as one person, to introduce enormous delays in the confirmations of officials by refusing to grant unanimous consent. Senators tend to be very, very, very reluctant to hear those kind of prerogatives questioned, as do sort of veterans of working in the Senate. It's part of what makes the Senate unusual among legislative bodies around the world. Individual members have a great deal of sway and influence in a way that backbench members of the House of Representatives don't have, in a way that backbench state legislators don't have. And so there's a tendency to have a sort of a bipartisan agreement that it's good to allow for these kind of holds and things like that. But I do think that Americans need to ask themselves whether, the interests of particular senators, and it's not the question of a minority or a majority at any given time, but are the interests of the country as a whole well served by this kind of process, or would it be better to make it simpler for the president to at least force a vote on all of his nominees in some kind of a timely manner? I think you especially see in the judicial context that there's been a downward spiral of sort of delays in making it harder to confirm people that's had a lot of different modalities to it. To some extent, filibusters, to some extent, the business about blue slips, which I'll defer to my colleagues as to exactly how that works, but it goes back and forth, gets very contentious. But the equilibrium result is not to advantage Democrats or Republicans. Both sides have found it harder to get their judges confirmed. And so the end result of it is simply more judicial vacancies than you would otherwise have. There's simply nothing you can do about the fact that the parties tend to alternate in power in our system of government. But by that same token, it's very difficult for any party to sort of unilaterally disarm. There's these enormous incentives to try to slow things down, keep the vacancies open until after the next election when the situation may be more favorable to you. But those exact same incentives apply always, 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 always. And so you're just getting a situation where you have fewer judges on the bench, you have fewer executive branch jobs filled with formal employees, and more of them being done by sort of informal counselor types. And it doesn't really help anyone, I would say, over the longer term. In terms of reform, I feel like there's almost sometimes too many clever solutions to this being bandied about in town. Ideas about putting more burden on the minority to do things, ideas about phasing it in slowly, ideas about a staggered push-in. I think it's clear that if you look at the history of reform of Senate procedure, the way it tends to work is that first you have some group of people who just really want to get it done, and they're threatening perhaps extreme measures, a constitutional option to force it through. And once there's a certain critical mass, that's when the idea for compromises starts slipping in. You say, well, we'll lower it from 67 to 60, or we'll lower the threshold, but we'll do it in the next administration. There's a lot of different kind of things you can do to reach the sort of consensus you need in order to change the rules. But the first step, I think, is not to frame specific solutions so much as it is to build momentum for the idea that there needs to be change, and that fundamentally the country would be better served by a system in which, of course, the Senate can knock down nominees if there's really a majority against them, but that otherwise people who are picked by the president get confirmed rather than being sort of stuck in a limbo that's based on delays and a fake pretense that there needs to be more debate about them. Debate is nice. We have a lot of political debate in the country, people arguing about things. I don't think that the consumption of floor time on the United States Senate while cloture petitions ripen and other things like that really constitutes a particularly edifying form of political debate in any way that's, relevant to normal people. It's very interesting to members of Congress and maybe to reporters who cover the Hill, but, there's not, I don't know. It's not intellectual giants going at it in a really brilliant kind of way out there, and so the real issues are just speed and supermajority or majority requirements. And I think there's considerations you can give in favor of supermajority rules for different kinds of purposes, but that we should be focusing on what's really at stake.
Great. Thank you, Matt. I have a series of questions, some narrow, some broad, but before I get to them, any of you itching to reply to any of your fellow panelists? Are you? Yeah, Marty?
Not to reply, but I just want to make sure people realize, and Macon touched on it at some point, what a filibuster is. I mean, you keep hearing the blogs, the House Democrats, Time Magazine criticize the Senate Democratic leadership at the moment, saying, make them filibuster. Just make them filibuster. Well, Mr. Smith Goes to Washington was a movie, and that's not real life. I mean, in the days of Thurman speaking for 24 hours, think of it, it occurred before you had internet and instant news. There was, Strom wanted to get the word out, yes, I'm standing here fighting this. And, you didn't do that just by telling the leadership, object to that for me, which is what people do now. And so you can have a filibuster and you can make them stay. You can make them stay before cloture ripens, and they'll sit out on the floor in a quorum call. As long as somebody's sitting there in a quorum call, the chair can't put the question. If they leave the floor, then you can tell them, you leave the floor regardless of whether I've already filed cloture, we're putting a question. We're going to vote without you. So you can force them to stay on the floor and ruin their day. And they'll get somebody to relieve them at 2 in the morning, and they'll go through shifts through the night. Same thing with once you've invoked cloture. You can stay all night for that 30 hours, and we've done it, but you can't force the person to speak. That 30 hours, you have so much time within it to speak. There's rules, you get an hour to speak. Time can be yielded to you through the leader or the bill manager in only a couple of hours. But a quorum call doesn't count against your hour. So that person, one person, if he's got a good enough bladder, can sit out there all night and keep the question from being put and burn that 30 hours. And with a little bit of help, you can see where 1 or 2 could easily do that. So it's easier said than done, quote, make them filibuster. Now, you can, once you've invoked cloture, 30 hours are running, you can prevent them from putting in a quorum and just sitting down. If you've got 51 bodies on the floor and the chair can look out into the chamber and that person puts in a quorum, suggests the absence of a quorum, only during cloture can the chair on its own look out and say, in the opinion of the chair, a quorum is present. So you have to keep speaking. And then, and you will see this before the year is out. And then, if we can get enough discipline, and then you will see the opponents have to speak. They'll have to take turns, but they'll have to actually speak. But that's about the only thing you can do, and that's only during that 30 hours. So, I mean, just want to make sure people understand that, it's not that easy to just make them talk. Sorry.
Excellent. I guess I'll pose this to the whole panel and take it if you'd like. First, on this sense, as Matt referred to, as sort of this downward spiral for the fate of judicial nominees, particularly for the appellate court bench, and increasingly, it seems, for the district court bench. Maybe you could talk a bit from either your inside perspective or post-Senate or outside perspective. What's the source, right? What's the causes of this conflict over judges that, for my noodling of the statistics, it looks like something roughly in the sort of early to mid-1980s, we begin to see the fall off in confirmation rates where it had been 90, sometimes 100% going into the 70s, and then more recently 50 or less than 50% of nominees being confirmed. Can you give us a sense of what is causing this to be this conflictual for senators?
I think the number one issue is the judicial branch and issues of social importance going to the judicial branch. I mean, we're having the judicial branch determine whether or not a person in Florida can die, whether or not a woman has a right to abortion, whether or not a president has actually been elected. And we are becoming more of a litigious society on every issue. It's going through California now, whether or not, the voters actually amended the Constitution, and there's a trial on the issue, despite the Supreme Court of California ruling on a particular referendum over there. Now it's going through the federal system. So we're challenging almost everything. And because of that, the interest groups on both sides have now, started descending, I think, in the Senate. I think, abortion and the Roe versus Wade in '73 and the organizations that formed after that, you saw that as a real, whether it's National Right to Life or NARAL and others, going to the Hill and expressing their views on who's going to get to the Supreme Court. Because whether you like it or not, those 5 Supreme Court justices can determine what the First Amendment is, what it's not, what the Fourth Amendment is, what the Second Amendment is, and all that. And it's a heck of a lot easier to make sure you have 5 judges on the Supreme Court, 5 justices that conform to what you believe your views are, rather than trying to get 67 United States senators and 218 members of Congress to do that for a constitutional amendment, along with all the other formalities that you need. So I think social policy interests heighten the debate on those issues, and the days of a Byron White being confirmed to the Supreme Court, or frankly, an Anthony Kennedy, or David Souter, may be over, because people go through and I think there's a certain self-selection. Nominees don't want to go to the bench, but then when they're already there, I mean, the process is so brutal on the personal and family lives of some of these nominees that I think that's the real concern that I personally have about the effect it has on the judiciary, effect it has on getting the best and the brightest, and that gets down to the confirmation process. And I don't think it's right. I don't think either left liberal interest groups descending on somebody who may have voted, ruled on a particular issue, taking it out of context and calling them, particular code words, or the right doing the same thing, saying that somebody has voted for a labor union and all of a sudden they're disqualified from serving on a bench. And I think we need to cool that off, and that's where I think you need to come to practical solutions. I mean, again, we can get into numbers and all that stuff, debating the sources of this, but you're right, it started in the 80s, and it's continually escalated. For the first time, you had that for Supreme Court nominees in early 2000s, in 2001 and 2. You saw that for the first time in the Circuit Court nominee when Miguel Estrada was filibustered. And it will continue to, I think, escalate or go spiral downward.
Matt or Marty?
Well, so something I wanted to add is that, not that there's any particular prospect for changing it, but the lifetime nature of appointments to the federal bench obviously creates a certain heightened tension around this. If judges had fixed terms, even if they were quite long terms, there wouldn't be the same level of interest, I think, in doing some of this delays. But the result is that you can have decades-long consequences if you can keep a seat open for 3 or 4 more months and put a new president in place. Whereas with executive branch appointees, where there have been problems with getting things filled, the fact that, there's bound to be a new president at some point, at which point control of the executive branch turns over, reduces some of the incentives to engage in this kind of behavior. And, more broadly, the Senate is an institution that's always been and continues to be governed heavily by norms as opposed to purely by rules. It's a big part of the story of the filibuster, is that for many years you always had the theoretical possibility of mounting filibusters, preventing legislation from moving forward, but traditionally it wasn't done all the time. We've moved over the years to a system where you have basically tit-for-tat reprisals, and each time one party pushes the envelope, the next party feels, I think reasonably, that you have no choice but to push it further, so that, once it's in motion, there's no real way to stop it.
Marty?
No, I think the fact that judicial nominations are lifetime appointments puts an entirely different cast to those nominations. Like, I would be all in favor of a majority vote on executive branch appointments, but I'm not in favor of eliminating the filibuster on judges. I mean, having the ability to filibuster a judge requires the administration to pick people that are mainstream, that are going to get votes on the other side of the aisle. We had instances where, under Clinton, and we're not going to get into the numbers of who got, how many got, votes, but there were a couple of Ninth Circuit people that were held up for quite a long time, but they were out of committee, and they were on the calendar, and we just couldn't get an agreement on getting a vote, but we finally were able to get an agreement on getting a vote, and lo and behold, had to be a cloture vote, and a cloture vote on each, but they handily won cloture. And yet the Ninth Circuit for Republicans is like, that's the other side of the moon. I mean, that circuit.
And for Senator Schumer.
Yeah, exactly. I mean, people, depending on their opinion of it, and yet these two nominees, Paez and Berzon, they were confirmed. They were confirmed because when it came down to it, the quality of the nomination was good. And they did appeal to enough people to easily get cloture. But it just took a while for us to be able, the stars had to align in order to line up those votes.
If I could just add to the, particularly Berzon and Paez nominees for the Ninth Circuit, it was, and I think Fletcher was part of that, they did get confirmed. And they did get confirmed after a couple of years. Mm-hmm. But there's something that's important as part of this debate, and whether we like it or not, it's just the way the Senate works. Mm-hmm. Those guys got confirmed, and the only reason they got the votes for the cloture was because there were other deals cut.
Yes.
There were nominees appointed, just like in the Sixth Circuit when President Bush nominated Helene White, and just like when he nominated Barrington Parker and Roger Gregory, former Clinton nominees, and Helene White on the Sixth Circuit was Senator Levin's, I believe, sister-in-law. And these were packages, and these were packages done to resolve some of these past grievances. That's the practical solution to them. So the only reason those nominees on the Ninth Circuit got done because they got packaged in with other judges who President Clinton appointed, who I'm sure, left to his own devices, would not have appointed.
There's been some references, both explicit and implicit, to the practice of holds in the Senate and their impact on keeping nominations after committee from being called up on the floor off the calendar. Perhaps you could say a little bit about the practice of holds, particularly on judicial nominations. In particular, the question that's always asked to me, which is, well, why don't, sort of akin to the make them filibuster, but why do leaders respect holds, by and large? I mean, why don't we begin to see a little more aggressiveness?
It's a time constraint, that's all. I mean, when Mitchell was leader, we would have people, someone would say, I've got a hold on that bill. And Mitchell, the chairman of the committee, would say, I want to do this bill. And then Mitchell would say, well, tell that person who has the hold, we're calling up that bill, we're going to move that bill tomorrow. A hold is not sacrosanct. A hold is only good as long as you can produce the member to come to the floor to filibuster. All it is saying, if you're going to go to that by consent, I intend to object. So all it is a notification to the leader that if you try to call up that nomination, in this case there's no motion to proceed, you can go to the nomination, but he will make you have to get cloture. And knowing that, then that becomes a time issue, because he may have other things, and he may not want to, or have the time to be able to, break the hold. Mm-hmm. But I mean, if you had the time, it comes down to a time management thing often, and unfortunately, election years, Mondays and Fridays on heavy lift days, so you're left with Tuesday, Wednesday, Thursday to get all your work done, and it's not easy to do that, especially if it's a hold on even assistant secretaries of some department as opposed to judges. But it's not a guarantee. There's nothing in the rule, and and as far as outing somebody, the place is a village up there. It doesn't take long to find out who's got the hold on something.
Is it your sense that time management problem intensified from your career there in the Senate?
It has lately, I mean, if you look at how many cloture motions were filed, and you averaged out in the Clinton and Bush era. Under Clinton, we averaged 75 cloture motions per Congress filed, and that was with Democrat and Republicans controlling. Bush, 67 average filed per Congress. And then you jump into 2007, 2008, the last year of Bush, when the Democrats controlled, and the number jumps from 67, actually in that year it jumped from 68 to 139. You know, it's a 107% increase. I mean, yes, it has gone up, and as some of the other panelists have said, because people are using it, this is a way of delay, because by forcing this cloture and making them spend that much time on it, then you can't get to that other bill. And, you know, knowing that you only have so many days, then you, in that effort, try to reduce, you know, the success, so in that case, the success of that Democratic Congress going into the election. And so, yes, it has gone up for one reason or another.
Macon or Matt on the holds in general, or other sort of harder to observe methods of obstruction or delay?
You know, not a whole lot to add to what Marty was saying. Like I said, you know, the holds are only as good for the minority to, I mean, you know, the hold's much more important, I think, in the majority, because then the leader does not bring up the matter, but if somebody in his own party does not want it. But it's only as good as somebody actually being there and objecting. And I think with judicial nominees, you know, in this past year, one, the pace of nominations, you know, you had one Supreme Court nomination and the confirmation in Justice Sotomayor, but you haven't had a lot of nominations being sent down by the White House, and it hasn't been a priority. And I think, you know, there's a lot of that that should be, we need to look at that as part of some of the delay, or why the numbers of confirmations are down. But the actual time it takes, I mean, the Democrats are in total control. The majority leader can call up any nomination. The Senate Judiciary Chairman can hold any hearing any day he wants. He can do whatever that, you know, they have the votes to pass it out of the Judiciary Committee. It's not like those old days when you know, Bush had a Democratic Senate to deal with. So I don't understand any kind of delay related to nominations, because the process, until you get down to the Senate floor, is wide open.
I do think, though, part of the issue is, you know, what kind of a system do we want? I mean, it's true that I think one of the primary reasons you have not had a ton of judges confirmed is that neither the Obama administration nor the Senate leadership has made it a particularly big point of emphasis. They've been focusing on other things primarily. At the same time, the question is, you know, why is it beneficial to the United States of America to make it the case that the only way to get your nominees confirmed is to make it a major point of emphasis? That, you know, you have, for example, a nominee to be Undersecretary of Treasury for International Affairs, who I don't believe is controversial in any particular way, but hasn't been confirmed, and hasn't been confirmed primarily, as I understand it, because of a time issue, because sort of routine delaying tactics would mean that it would take a lot of time just to sort of get her up there and get the vote done. And she's in the building and she's working, and if Tim Geithner wants to know what she has to say, you know, he can get her on the phone. So it's not considered an important priority that, you know, they need to sort of throw their shoulders into. If they did, I'm sure they could get it done. But, I mean, again, why am I better off? Why are you? Why is the country better off for living in a world where you can't just have people routinely confirmed? You know, what has actually been achieved thereby? And I think you see a similar point on the judicial lens, that, you know, it's true that in a pure sense of finger pointing and who's to blame for the slow pace of confirmations, that you could say, in a sense, it's the Democrats' own fault. In a larger sense, you know, there's vacancies on the courts. There are all the time. There will continue to be vacancies as there are different presidents, different Senate majorities. And, you know, wouldn't it be better if it were just relatively quick and painless to have them filled, unless someone wants to make a major point of objecting to them, right? I mean, what is the benefit exactly of making it so difficult?
I guess before we open to questions, just there have been a series of reforms that all of you have suggested along the way. Maybe we could take a stab at your sort of top three or top two, if there's something you could change about confirmation process here, particularly for lower court judges. Put aside the political feasibility, think about, are there changes here that should seriously be considered? And then maybe on the side, whether they'll ever be politically feasible. And just to throw one out that's not come up is there's a growing number of senators who set up these either bipartisan or nonpartisan or sometimes partisan selection committees within their states to at least generate candidates for the White House to consider, or at least to generate for the senators to choose from to then to suggest to the White House. In that in particular, do you see that taking foot and growing? And is there an incentive to use those? And how do you see this?
I think there's an incentive to use those. Obviously, you're never going to get anything passed that's going to put that into statute, because the executive branch would, look upon that as infringing on their right to choose. But they do come in handy. I know Senator Feinstein and Senator Boxer have had, California being such a huge state with so many judges, they've had a recommendation process going back for many years, and it's worked well for them. Other states have different spins on it, but I think as an advisory tactic, it can be helpful to whoever administration is in power, but I don't think you could ever institute it because of that.
I agree with Marty in that I think, whether it's even if it was passed in statute, I don't know if that would be constitutional. No executive branch would ever want to limit its own power to do that. But the issue is, I think it's up to each of the home state senators to have their process. Now, in the example of California, a place somewhat near and dear to my heart, is that it worked generally. It was working for U.S. attorneys and district courts, and where there was a rule between the two home state senators and the folks, President Bush's representatives in California. They produced, they had some kind of a rule that 4 of the 6 nominees, I think 2 was appointed by Senator Boxer, 2 by Feinstein, and 2 by President Bush. 4 of this, as long as 4 of the 6 agreed, then the nominee went through with, unless some of the senators, they couldn't bind the Senate, but the good faith agreement was the 2 home state senators were fine with it because they had their representatives on the bench. Until Jim Rogan was nominated. Through that, came out with a majority. Senator Feinstein was fine getting that through. Senator Boxer refused to allow the nomination for the district court, who came out of that commission under its rules, to get confirmed. And I think because of that, and look, those commissions were anathema to the conservatives at that time. But President Bush and his representative, Jerry Parsky, out there, thought that was a good way, and it really worked, I think, for about 6 years during that process, despite conservatives saying, look, we're not getting the type of people we want, but they were mainstream folks. Because of what happened to Jim Rogan, I think it is very unlikely that that type of a commission will ever work again, at least in that state. Now, it works very well, I think, in Iowa between Senators Grassley and Harkin and others. But it has to work on good faith, and the parties involved need to live up to the deal on both sides of that.
Matt, other thoughts on reforms or changes or?
I don't have anything particularly brilliant to say, other than, I think that a basic system of majority votes as a decision procedure, it works well for legislatures throughout the United States of America, throughout the world, and a presumption should be that that's how we confirm judges and everyone else. The politics of getting there seem murky, but it's a good idea.
Fair enough. Okay, I think we'll move to any questions from the audience. First, is any questions from the press, if you were to go first? And also, if you could, when the mic comes around to you, if you could, hard to see you all here, if you could identify yourself for your question. Yep. Okay, that's fair.
For the Democrats throughout the 70s informally, 79 and 80, I did them formally for Judiciary. And in 1975, I orchestrated the change in the rule and wrote the script for Mansfield, Mondale, and Rockefeller. There are 3 or 4 points that just didn't seem to come up at all. One is the impact of Mansfield's double tracking. He instituted, as you know, the idea that you could do the filibuster in the morning and in the afternoon another bill, which takes away the pressure of people who want something. In 1970, when the conservatives realized how broadly the Voting Rights Act, Section 5, would apply, they were dead set against the first renewal of it. But Mansfield put Judge Cardwell's nomination behind it, and that's the reason why eventually they stopped filibustering. So when you double track, you just take away that tremendous pressure. At the same time, Mansfield, in the civil rights area, illustrated the benefit of multiple cloture, because you've talked as if everything that goes on that's relevant is in Washington. During multiple clotures, Johnson and Mansfield, and we did it in the 70s on other things, Hart-Scott-Rodino antitrust law, you build up pressure around the country. On the health reform bill, when one person said, I won't do it, the other senators were vague as to how they would vote. When you force a cloture vote, you enable the interest groups and the president to put pressure on members the next time round to vote for the cloture. Two other things very quickly. On the executive branch nominees, except for a few, like current ones in justice, most senators' attitude is the president is going to get someone who will do what he wants. If we don't get this person, he'll put up someone who will be roughly the same. So that's the area where you see it over the last few decades become blackmail, because those filibusters, as you know, are mostly about a senator getting something that has nothing to do with the nominee or the bill, but mainly the executive branch nominee, whatever it is that he wants. And lastly, on the rules change, the change from the perpetuation of a requirement of 3/5 or 2/3 rather for rules change is not a problem, because the same parliamentary rulings made by Rockefeller in '75, if made by Biden now, would enable the Senate to change the rule by 50. In fact, the ruling that Rockefeller made actually paved the way for a 50% majority. That's what Mondale's motion was. It was only an off-the-floor compromise of the kind that Mr. Iglesias said that brought it back up to 60, so that's not a problem.
Great. Any thoughts on the issue of tracking or other treatment of nominations here? Or other?
I just want to say, I think it's remarkable how poorly understood the dual tracking issue is. I brought it up, with I've talked about this with, a member of the cabinet, a couple of actual senators, former White House chief of staff, and nobody is familiar with this issue, which, as you explained, is really critical to how it's changed over the decades.
Other, sort of C back here. Yep.
Hi, I'm John Mulligan from the Providence Journal. One thing I've heard come up in discussions of who shot John, who started the escalation and so forth, is what Democrats say in response to the Republicans' response to the current situation. Democrats say, well, yes, we did it too, but that's because Bush invented something new under the sun. He ceased to honor the prerogative of home state senators, and consequently, we had to delay. First of all, is that correct? Was that something new under the sun that Bush began doing and other presidents had not done? How pervasive was it, if correct? And is that an important part of this big picture, or something trivial? Thank you.
The issue of consultation is an important part of, I think, of the confirmation process. The president can only nominate, and only with the advice and consent of the Senate appoint. But I don't, I was there during the early part of the Bush administration. As far as the home state, if you did not consult, remember, the Senate, for confirmation purposes, during all of the 8 years of Bush was only controlled by Republicans for 4 of those years. The very first 2 years, June 1st is when Senator Jeffords flip-flopped and the Senate control went into the Democrats' hands. The first nominees were only nominated, I believe, May 11th of 2001, and there was not a single committee action taken other than a notice for a hearing, which never occurred on John Roberts and Miguel Estrada. But during that whole time, you know, you have the blue slip issues that is really more of an agreement amongst a cartel of 100 senators that is more important to the senators than whoever the heck is in the White House. I mean, you want your county commissioner to become the U.S. Marshal or district court judge or U.S. attorney or whatever. It's got nothing to do with who your party's president is. It is your prerogative in your home state Senate, and those guys guard it amongst themselves, and the blue slip has been honored. I can, you know, look, Michigan nominees, a lot of the problem with the Sixth Circuit Court that continued to go back and forth, as well as the Fourth Circuit, was President Clinton nominated several Sixth Circuit nominees without ever consulting with Spence Abraham, who at the time was the senator. And that created a broader issue, and he wanted, you know, that to be resolved. And then the Republicans, after he left the Senate, still remembered that, and the grievance process started. So who started it, I don't know, but I can sure tell you it wasn't Bush who started that, if it ever occurred under his watch. It did occur in the very beginning, the first couple of months of Bush. He never nominated. He, without consulting the senior senator from California who sat on the Judiciary Committee, there was rumors that he was considering nominating Chris Cox for the Ninth Circuit, you know, who is probably as utterly qualified as anybody to sit on a bench. But he didn't. Lots of Republicans, as well as Democrats, told the president at that time that this was wrong for him to be doing that. And that was in the very beginning, the first few months, where there was talk about doing that. And he never did. He withdrew that nominee, and he only nominated, I believe, 9 in the very first batch of Bush. All of those, every single one of those, were consulted and had the support of the home state senators.
It goes back and forth. I mean, you know, as he said, you know, President Clinton in the Abraham instance, President Bush in other instances. The problem with President Bush was he expanded it to other things and lack of consultation. I mean, there are boards and commissions that have representation built in by law, Republicans and Democrats. And it was always, you know, under Clinton, it was no problem, you know, you waited to find out from Dole a lot, you know, which Republican they wanted for that slot. Many times under Bush, they would find their own Democrat, quote, Democrat, for those slots without any consultation. It was breathtaking how much they ignored the advice prior to sending up appointments. So and then also doing some appointments through during recesses, after, in one instance where we were told they weren't going to do some, which is why thereafter, near the end, Reid wouldn't go out of session again because he couldn't trust their word. And we had a pro forma session every 3 days in that last year. And, you know, recess appointments. So, I mean, you know, I'm not going to get into a he said, she said. Both sides, both administrations are probably guilty, but we felt we also had a problem that grew even stronger, and it went to other nominations, not just judiciary.
Yep.
Okay, I'm Glenn Sugamelli, and I've run the Judging the Environment program for the environmental community since 2001 on judicial nominations. And just a couple of points. First of all, I think one of the things that Bush did that was different was he not only didn't consult with home state Democrats, he sometimes didn't consult with and went beyond that with home state Republicans. In Virginia, there was a nominee who John Warner had actually interviewed and rejected. and that was the one who was picked, even though they came up with a whole range of people who would be acceptable. They're clearly, and I've written op-eds and other things on this in Politico elsewhere, clearly at a certain point what Bush was doing was picking people because he knew they wouldn't be nominated in order to create an issue around it. They wouldn't be confirmed. I mean, he did the same thing with Claude Allen, where he tried to change the seat from Maryland to Virginia, and this is before Claude Allen pled guilty to shoplifting. But, you know, so there were reasons why he was blocked, but it was really down to where both Maryland senators had to come and testify at the hearing saying this is a traditional Maryland seat, you can't steal it and go to Virginia with the seat. So there were a lot of things that were happening under Bush that really were unprecedented. A couple other quick points. First of all, the commission, you mentioned the point about the Feinstein and Boxer commissions. Right now, one of the two district court nominees have been blocked and forced to be renominated. One came out of a California bipartisan commission, one came out of a Wisconsin bipartisan commission, and it was the same bipartisan commission that nominated Diane Sykes, who Feinstein has said he did not like, but he went through with, and now they're turning it back and quoting her against the current nominee. So there's, even when you do go with a bipartisan commission, there's still problems. And the thing that I have never seen before, as much as I was very much involved with the issues during the Bush administration, when there were people blocked, there were issues. Right now, Barbara Keenan was nominated for the Fourth Circuit with the strong support of not only her home state senators, but the current Republican governor of Virginia, and it required a cloture vote with zero debate against her. I listened to the entire thing. Not a single person stood up and said a word against during the cloture time. It was a 99-0 cloture vote, and then a 99-0 vote on the merits after Sessions spoke for 1 minute praising her. So, I mean, that is just shows that that was surely for the sake of obstruction, delay, generally had nothing to do with the merits of that nomination. And when you have to do that for that sort of consensus nominee, it clearly basically puts a pale on all the other nominees where there may be a little bit of concern. This is somebody who came out of committee unanimously in a voice vote. So the system has really gotten to the point where even the most non-controversial nominees are being delayed, and that really is different. With Bush, the ones who were being delayed, there really were records of them having controversial issues, or there was lack of consultation, or there was actual deliberate provocation of a number of senators in New Jersey and Virginia and elsewhere, or else there were even Republican opposition, as in one of the ones Haynes was tied in with the torture memos, and Lindsey Graham was opposed. So, anyway, any comments on that?
Yeah, with Keenan, I mean, I don't know what the complaint is. Cloture was filed, a request to end the debate and bring the matter to a vote, which is the right of the majority, and Republicans all voted for that. Do you want to know how many clotures were filed on Miguel Estrada? What was the problem? It was a conservative Hispanic, the first one appointed to the D.C. Circuit. He came from a different point of view than other people wanted, rightly or wrongly. He was voted by the ABA. Well qualified. He had no criminal issues. There was no issues there. Same thing with a few others who got through, but only after the Gang of 14. With respect to the California nominees on the district court, look, the two home state senators are Democrats. The Senate enjoys 59 United States senators of the Democratic Party, something Bush never had in any time. The committee is controlled by the Democrats. I mean, why aren't those brought up? Why isn't cloture filed on them? Force a vote. We had to do that for court of claims. It's something that somebody once called in the academic press, it's a court without any apparent jurisdiction. We had to file for court of claims that went unanimously. I mean, that is, talk about meaning no disrespect. I have a number of friends on that court. But it is, come on. There's no social issue that's going to be reviewed by the court of claims. But it was obstruction. Obstruction started. And, I went back to, we can look back and point fingers, going all the way back to the 80s. Looking back to Biden, Bush 1. Looking back to, all of those, Hatch, Clinton, all of this. But I think the issue is we all know what the problem is. We got to be honest about it.
that our interest groups on the left and on the right put pressure on the senators, and unless they have to vote, they won't. And that's the ultimate issue, and that's our political process, and that's what the Founding Fathers wanted, and that's what it is. What I'm talking about is moving forward is what is a practical solution that I think solves a growing constitutional problem, in my view, by imposing a super majority constitutional requirement for the confirmation of the third equal branch that is there. But there's a practical solution. That cannot happen tomorrow by folks. Because, folks will argue that's the Senate's prerogatives, it writes its own rules, Article 1, Section 5 allows it to do that, blah, blah, blah. But I'm talking about the practical effects of this, practical effects on people, practical effects on the life of these nominees and the best and the brightest wanting, take away judicial pay. Who wants to go through that process? I'll leave it at that.
Other strongly felt reactions. Okay. More. Yep. Oops.
Look, to some extent, we have to be realistic. There is in one party a concerted interest in Supreme Court nominees that is not in other party. The Democratic Party tends to be ambivalent. The Republican Party is serious to their base. Now, let's not pretend there's an equality of concern in these parties. There is not. The they are interested in legal Darwinism and the conservative issue, and those are the kind of justice they want. Now, the 3/5 thing, you can understand the 3/5 majority, how it kind of rings with me personally. To what extent is this culture of 3/5 majority goes back to the compromises that were made in the original Constitution for 3/5 as a quota to give white slave owners disproportionate power in the legislative, disproportionate racial quotas in the Constitution to give disproportionate power to the southern states in the president and the electoral college. To what extent is our inability to address the complexities we have with the requirement of supermajorities is grounded in our denial of these unsavory origins of why these supermajorities were compromises to preserve white racial privilege in the original Constitution. I don't think it's any accident that these supermajorities in the original Constitution that established white privilege quotas are still impacting. We are reaping the whirlwind, to tell you the truth, of those compromises. And we pretend that they have to do with federalism. They have to do with minority concerns, with over-controlling the minority. Hell no. They had to do with compromises to give disproportionate privileges to white minorities to maintain white privilege. If we talk about the origins of these supermajorities, maybe we can be more honest in getting a public to address a solution where we go to simple majority, which is supposed to be democracy. It doesn't exist anywhere in other so-called developed democracies, only in our democracy. And it directly relates to our inability to talk about, to address the unsavory origins of what supermajorities were required to amend our Constitution. The southern states want to make it clear that if white privilege gave up its power, it wouldn't be that we just think about it and to be a simple majority. Damn it, we better be sure to a supermajority give up on our privileges.
I'm going to take your point about supermajorities and ask it as a slightly different question. The Senate does adopt fast track periodically, whether it's for budget, as we all know, for reconciliation, or if it's fast track for trade agreements. And we see it a bunch of very minor bills as well as larger laws. Could there ever be fast track for judicial nominations why might senators want that? Why do you think senators might be reluctant to adopt that? And is there any hope for that as a potential reform?
I can see, it depends on whether you think you should still be able to have a supermajority to, invoke cloture on a nomination, on a judicial nomination. And the fact that they're lifetime appointments and can have impacts far beyond an administration, I think it will lean towards people wanting to keep a cloture situation for a judge. I could see changing and how that cloture is required, or cutting the time from 30 hours down to 2 hours if you were to invoke cloture. But that's just my opinion.
I mean, there's really no constitutional requirement of how the advice and consent of the United States is granted to the president. Getting to 3/5 in the Constitution, I think the issues of race have haunted this country. And I wasn't born in this country. I came here when I was 10. I came as a minority of another country, and I'm a minority in this country. And if people think that there isn't racism that goes on even today, they're wrong. They're fooling themselves. And it's a dark history of this country, and obviously, evidently, it was present at the time of the writing of the Constitution. Probably is still present in individuals in certain pockets of this country. But the Constitution, with the adoption of the 13th and the 14th Amendment, have, I think, addressed the issues. The requirement for 3/5 is a rule of the Senate that came in 1975. What's that? Yeah.
It rains ironic.
Well, there was, look, I don't think there's anybody would argue that there's a greater civil rights advocate that the United States had than Ted Kennedy, right? Senator Kennedy was the one who offered those amendments in 1975 to allow for amendments to be filed post-closure and, on this issue. He allowed it because he wanted to slow certain things down. And I don't think wanting debate is an issue that it goes necessarily to a particular race. And I think, unfortunately, by definition, a simple majority can oppress the minority. You don't need 3/5 majority to oppress any particular minority because, again, by definition, they're a minority of the majority. So I don't think that's really helpful about that debate with respect to the cloture issues. I mean, we're dealing with issues of health care and other things that have nothing to do specifically with, civil rights or minority rights, but a broader policy, and I think legitimate debates on both sides. Folks want a certain thing, folks don't want a certain thing. Folks want Miguel Estrada, folks don't want Miguel Estrada because they believe he'll rule a certain way. And I think that's probably a healthier debate, is looking at the impact of this and what the underlying Constitution is, and whether or not, and on statute, sure, they can pass that. I don't know if it's needed. Frankly, you can, 51 United States senators can sign a letter sending it to the President of the United States saying, we do, the undersigned, duly sworn United States and elected United States senators of the 111th Congress or whatever, hereby consent to your nomination. And the President gets to appoint and sign that commission. That's one way to do it. I mean, there's no requirement of how it goes about it constitutionally, how it's done. Now, you want to talk about a nuclear option, that's one. But, and a litigant will be forced, who loses before that panel, will be forced to sue and say he wasn't duly appointed, and whether a court will ever get into that issue of political debate is a whole different story. But, who knows? Maybe another Supreme Court will determine how they're nominated. And then we never have to deal with any debate in the United States Senate as long as 51 are willing to sign. I mean, just to have a wacky idea for you, but. Supreme Court?
Yeah, for the Supreme Court. And what was interesting about that nomination is David Cheney standing there. And he was denied his seat because he had signed a bill. He had helped Andrew Johnson draft a bill denying the civil rights of passage. Okay, so the president at that time said, well, you know who that killed. I will select another judge just like him. Do you know what they did? They then said, okay, they abolished the seat. And that's how we got from 10 justices down to 9.
Okay, other questions? The two over here.
I'm just curious, as I read Rule 22, there seem to be two different standards for the time limit post-cloture, the 30-hour and the 1 hour per senator. Historically, over the past 30 years, how has that operated? Has it mostly been the 30-hour, and why the discrepancy?
It used to be 100 hours, and that's why each one had an hour. But in '86, when we went on TV, Senator Byrd, in that rules change that allowed for TV, put in rules changes in other areas, and they were agreed to. And one of the rules changes that were put in was dropping the post-cloture time from 100 down to 30, but that was the only part they changed. They didn't change the other part that still gave everybody a guarantee of an hour. So you can see where it doesn't really fit. Fortunately, it's never been a problem. And at the end, you'll notice, if you didn't get to speak, you're also entitled for 10 minutes. So if it did become a problem, there is that safety valve.
Yep, next door.
Victor Stone. I had two questions, one historical and one practical. The historical one is whether or not, we didn't hear about this, so I just wonder, it sounds to me like the senators have decided as a group that they could capture the judicial nominations. I frankly don't know why constitutionally it's any of their business whether or not a nominee comes out of their state who's going to serve in the bench, because we do know that there's lots of people who move around this country. They were born in one state, they move to another. I mean, we have senators, whether it's Hillary Clinton or Bobby Kennedy, who didn't have long time associations with the state they came from. So why, it sounds to me like the Senate decided to capture that in their rules, and I wonder if you go back to the early 1800s, whether it was the president's decision to nominate someone, and he didn't pay any attention to what the commissions or the sitting senators wanted, and he just looked for their 51 votes. Then the practical question that I have is, why do you think, if it's possible, maybe it's not possible, a president doesn't just say, fine, I'm going to make a recess appointment, and certainly for his executive branch appointments, just casually start making reams of recess appointments on stalled nominations, and threaten to do it with judicial nominations too, to break this logjam where people don't want to, where they want to stall, because it looks to me like they want to blackmail for many other different reasons that have nothing to do with the nominee.
On the historical one, look, as an antitrust enforcer, I'd go back to there's a cartel of 100 senators, and cartels have incredible power. What happened was, and I believe it was in the early 70s, is a senator elected a political rival of his own party, of a home state senators, all three of them are the same party, to a judicial bench, which that home state senator thought was embarrassing, and a big embarrassment to himself at that time. And so they put in this rule of a blue slip, which is honored amongst themselves, and all the blue slip is basically says, I consent, this is from my home state senator, it's a practice that the chairman of the Judiciary Committee sends to each of the home state senators for whom that nominee is nominated for that seat. And they say, yeah, I'm fine, go for it, no, or they just don't return it. And that is a practice, it was a prerogative of the chairman, and Senator Kennedy was the chairman of the Judiciary Committee, I believe, at that time, and I think Justice Breyer was the chief counsel of the committee at that time. Would they impose that rule? I'm not positive, don't quote me on that, but what they did was say, hey, as courtesy to my fellow senators, I will not move on this nomination unless I hear from you. And now, that rule has been in place and it's been institutionalized, and once there's a word change of when you can overcome that, because now it's been used as a veto by the home state senator. So you're right, constitutionally, there's nothing requirement. It's just a practical rule of the United States Senate, and that was put in place for that reason. It is, it's, I think, again, it's a practice. With recess appointments, it has happened President Clinton did them, President Bush did them. I assume others have done them. The Senate has gotten smarter with Marty's help here in figuring out ways where even if you're gone for a couple of months, you're not in recess, because some senator would fly in and open up the morning business and then go away. And, and you'd rotate that. So the Senate is technically never in recess and therefore cannot invoke the recess appointment clause. The president cannot invoke the powers of the recess appointment clause of the Constitution.
The other issue with recess appointments is that people don't necessarily want to get recess appointments, that it poisons the well against you to ever get a normal confirmation vote in the Senate. People, who are living around the country, who have jobs, don't want to come to Washington for a temporary appointment that's accepted in a way that will put you under a sort of a cloud of suspicion with other senators. So presidents have normally been restrained in their practical ability to move forward with that kind of thing.
Yeah, and as you said, you've got that hanging over you, and a recess appointment's a temporary appointment. It's good till the end of the next session. And that might work for the end of administration, where people are filling, these administration jobs. But certainly a judge wouldn't want to do that, give up his lucrative law practice or whatever he's doing to only take a 1.5 year judicial appointment. Maybe at some point they would, but as you say, then it would be more and more difficult for you to get confirmed. And as opposed to a lifetime appointment, would you want a 1.5 years, 1 3/4 appointment?
I would just add on the historical question that, right, recall that the Constitution allows and sets for Congress the ability to create these interior or inferior courts. And so you're absolutely right that this is a matter of sort of Congress taking charge and crafting. And there were dueling court plans early in the 19th century, but the decision early on was to make the district courts, or what they were called then, contiguous with state boundaries. And once that gets put into place, it's hard to dislodge. And the expectation then was that presidents, in fact, wouldn't know who the good candidates were and would turn to senators for advice. And that advice gets offered informally, and it gets formalized with the blue slips early 20th century. And it's very hard, as we've all seen, for all these discussions about when we put practices into place, they're very hard to dislodge because senators impart gain from them, and it's very hard to move the politics around that. And on that note, with a, are we one last? Okay.
I just had a question regarding the practical solution that you put forward. It's really sort of two issues with it. One, or questions. One kind of more, not necessarily constitutional, but theoretical, and the other practical. The theoretical being, it sounds like if you have, using at least one of your examples for a practical solution, if you have a Senate adopting a rule but saying that this rule applies in some future Congress, it's almost like they're legislating sort of a super rule, or something that has authority over the rules. Maybe I'm not understanding that correctly, but it's almost like they're setting legislation over how the rules should be done. And then simply the practical question, it obviously relies on trust that people will play by those rules in the next administration. It seems that the whole problem is that there just isn't trust now anyway.
Well, as far as binding future Congresses, that's been a 200-year debate, but the Senate's a living body. You can have a rule and then have it effective, or just like any statute. You can make health care pass and not be effective till 2014, or the taxes don't come in till 2013, or whatever that is, all the various elements of that. So I don't see there's any problem either constitutionally, or it's the Senate making its own rules and how it operates. So you can do that and say, look, with starting January 20th, 2017, this is how, or 2013, this is how we're going to operate. I think that's fine. Again, another, and you do that under the current rules of the United States Senate for how it goes by in amending it. I think it takes some courage to come up and do that. I think, some former judiciary chairman, it's got to be bipartisan. It's got to be some elders getting together and say, this is how we're going to deal with it from here on. And perhaps former presidents getting involved. I would love to see President George W. Bush and President Clinton getting together and saying, look, this would be a good way of dealing with it. We were both presidents. Our constitutional prerogative was hurt, and maybe you get Senators, Dole and Daschle involved with that as former Senate Majority Leaders, and advocating for such a thing. With respect to, what was the second point? Was just that it does rely on trust. Oh, well, you're changing the rules. I mean, any time the Senate's rules, but if you did that, I mean, it becomes equally difficult to reverse those. So it's not so much the Senate, it requires, the whole process and a supermajority to actually change the U.S. Senate's rules. So I'm proposing, an actual solution that would go within the current rules and hope to get, hopefully it'll get, the only way it would work would be if you had a bipartisan and a pretty strong majority, just like when the original Rule 22 was put in place back in 1917.
Other reactions? If not, I'd close on the observation that reform is possible in the Senate, but it's few and far between. But thank you very much for coming, and thank you for the American Constitutional Society for having us all.